Hello, and welcome to our Stepping Stones podcast, supporting individuals with each step of moving to and from the US and the UK. I'm your host for today, Scott Barber, partner at Buzzacott, and joining me today are
Christy Jackson, I'm a partner and head of the US practice at Laura Devine Immigration.
I'm Matt Conan, Chartered Financial Planner at Westminster Wealth Management.
Gurpreet Singh, Associate Director in Buzzacott's expatriate tax team.
In this episode, we'll discuss Brits moving to the US, and to get started, let's share the story of our client, David. David is a British citizen, resident and domiciled in England from a UK tax perspective. David and his family are planning to move to the US, specifically New York, for a few years, where David is taking up a position as a full-time employee at the US subsidiary of his current UK employer, and he is a first international secondee employee. David's investments include his family home in the UK, which might be rented out, a self-invested personal pension plan, or SIP, individual savings accounts, or ISAs, invested in a number of UK unit trusts, and cash in various bank accounts. In step one, we'll discuss pre-immigration planning. Everyone knows that there are differences between the US and the UK in terms of language, in terms of which side of the road is the correct side of the road to drive on. In this section, we'll discuss immigration issues around visas, investment issues, and tax issues. Christy, as a starting point, what are the potential visas that David or his employer might look at?
So it is a challenge because every case in immigration will depend very, very much on the facts. So going on our case with David, we know that he works for a UK employer and he's going to be seconded to their US subsidiary, so we know there's a corporate relationship. We most likely would be looking at an L1 intercompany transfer, provided that David has worked outside the US for his employer for at least a year. There are some alternatives. We can look at E2s if the UK employer and indeed the US entity is British owned ultimately. So that's something that we'll often do because sometimes that visa is a little bit more flexible and it provides the employer with greater opportunity to send more employees in a faster way. So typically the L1 or the E2 would be the most appropriate visa when an employer wants to send an employee to the United States.
Okay. And specifically, what do you think would be appropriate in David's circumstances?
So again, I think normally I would go through an exercise of determining the ownership of the entity to work it out. I prefer an E2 visa where we can do an E2 visa because it is a longer one. So I think either would be appropriate. Some things that we may consider though might be how long the assignment is. They've said that it is meant to be short term, just a few years. But we know that sometimes a few years turns into a much longer time. So in my opinion, I would probably try first for the E2 visa, which is based again on treaties. So the US has a treaty with the UK, so it would need to be a British owned company ultimately with British shareholders. And it would require a substantial investment in the US, the E2 does. So the company will have needed to have spent money to start up the US entity. If for some reason it doesn't work, because they're not British owned or for any other reasons, maybe they've not made any investment, then the L1 would be the backup option. It just sometimes takes a little bit longer to get and has a little bit more of a uphill challenge.
And what about the spouse and the children and their right to live in the U.S. and possibly work in the case of the spouse? How does that play out these days?
So it's good news for this type of case because the L1 and the E2, which again is the most likely visa scenarios here, both do allow spouses to work. And recently they have removed any requirement that they obtain pre-authorization to work. So that means that a spouse could enter the US with their brand new visa and effectively begin working that day. So it really is actually quite good for the spouse in both of those scenarios. There are other visa categories, not probably appropriate to David, but they wouldn't allow the spouse to work. So that's why these two are actually really going to be good for David. Unfortunately, the children cannot work, but they can go. They must be under 21. And once they do turn 21, we will have to consider alternatives. So they can study, as can the spouse. So if the spouse decides she doesn't want to work but would rather go do a master's program, she could do that as well. So in both cases, the L and the E, the spouse can work, the children can study but couldn't work until 21.
Okay. And from the various visa options, what would be your preferred route in this case?
So I would normally say that the E2 is going to be the preferred route in this scenario that we have with David, because it does give a longer visa and a little bit more flexibility for the employer. I do think that while the L may work, some of the things that we may consider would be the time frames that are needed. And in this case, the E2 does give the most flexibility. So I would probably recommend the E2 if they do qualify.
Okay. And Gavi, what does David need to know about the U.S. tax system before he goes?
So I think one of the first things I would say is the tax pre-planning should be done several months in advance, because we have clients who come to us very late in the day and they want to get pre-planning done. So once David becomes U.S. tax resident, he will be taxed on his worldwide income. So income he earns in US, UK, so that will be taxed. David need to ensure that his foreign income is also taxed in the UK as well. So his UK rental income, his investment income, SIP, that will be all taxed in the US as well as it will be taxed in New York. In addition to that, David also needs to pay UK taxes on his UK source income. So there will be taxes payable on the rental profit as well as his investment income in UK. So to avoid double taxation, there is an income tax treaty between US and UK, and that's what will come into play, and which is very useful. This is where if UK taxes are paid on time in the right calendar year, then David can take credit for those UK taxes on his US return to reduce his US tax liability. We need to be careful because with New York, not all the states allow foreign tax credit relief, so this wouldn't apply to New York. So there will be New York taxes to pay in addition. In terms of residency start date, when that would start for David and his family, so normally the residency is established based on whether someone is US citizen, green card holder, or non-resident alien. Given David and his family are not US citizens yet or green card holders, what we will need to look at is the residency will be established based on substantial presence test. What this test does, the first part looks at how much time you spend in the US. If you spend 183 days or more in the calendar year, then they will become resident from start of the year, from 1st of January during that year. And then the second part of this test looks at how much time you spend in the US in the last 3 years. So given David hasn't spent any time in the US in the last 3 years, so there is no, we don't need to look at that, so that test is not relevant. In addition to federal state taxes, US also charges state taxes as well. So there are 42 individual states that charge income taxes, including New York. So that will be extra layer of tax for David and his family on their investments and income. Depending on where David is resident, there's also local taxes. So there will be could be New York City taxes on top of that. And then once David has moved to US, the next thing we need to work out is what point David breaks his UK tax residency. For this scenario, we need to look at something called statutory residence test. This will establish when David and his family break UK tax residency and start US. Given David is moving to US from 1st of January, that's when and he's going to move to US to work full-time abroad. That's when he will meet one of the tests in statutory residence test, and he will become resident. He will split his UK residency at that point. So what would happen is David will be resident for part of the year in UK and non-resident for the rest of the year. So that will be split in 2 different parts. One thing we need to know is wife and kids will need to go through separate tests, because in the UK you file individual tax returns and the tests apply to individuals, so you would have to go through the test separately.
And I think it's true as well that he also needs to be prepared of the differences in filing. So the US is a calendar tax year as opposed to this slightly odd, I get to say that because I'm American, fiscal tax year that you have here in the UK. And there's also a lot more deadlines and a lot more information reporting, particularly for assets outside of the UK, or forgive me, outside of the US. So what are the types of information that he will need to provide to the US that perhaps he's never needed to provide to the UK.
So as you said, yes, because it's calendar year based, David's federal tax deadline would be 15th of April after the end of the calendar year. And then also applies to New York. In relation to getting information, there will be a lot of information that David will need to provide in relation to his investments. For example, David has an ISA in the UK, which is tax-free in the UK, and he probably never needed to look through his statements to provide the information. Whereas when it comes to US, it's a look through, so you have to provide individual statements and what's been earned in that account, as well as SIP as well.
And can we just discuss briefly, the current plan is to rent out the main UK residence, but what happens if he decides to sell it whilst he's US resident?
So I think David and his wife should consider what the ultimate goal is. If they want to sell this property in the next couple of years, our recommendation would be to sell before you become US person, because in UK you get relief, which is called principal private residence relief, which is if you live in a property and it's been your main house throughout the ownership, then that is not subject to UK tax. Whereas in US, there is US tax, and as well as New York and New York City. So if David is looking to sell, then he should do it beforehand. You get some relief in US, so if the properties are jointly, David and his wife will get up to $500,000 of tax-free allowance, so that would come off any gain is made. But anything in addition to that will be subject to federal New York and New York City taxes. So that's something they will need to consider.
Yeah. And it's an important point as well, because it does demonstrate that even though there's a tax treaty between the US and the UK, that treaty is designed to eliminate double taxation. It doesn't stop one or the other system from imposing a higher tax. So if someone's an American or a US resident selling property in the UK, even if that's gained as tax exempt in the UK, the US can still step in and say, but you're resident, so we'll tax you according to our rules.
Yeah.
And it's an important thing to understand.
And one of the things I would like to mention is this exchange rate can play a quite big part as well.
So as the next step, we've talked about immigration and tax, but what should David be considering in terms of his current investments that he has in the UK? We've mentioned the SIP, we've mentioned the ISAs. There's some potential differences there. What should he be thinking about?
There's quite a lot of points to consider when thinking of moving to the States as a US individual. So if we look at, first of all, the SIP, first of all, will the provider actually want David as a client moving forwards? Often, if you have a US address, the SIP provider will ask you to leave. And it's becoming more and more difficult in the pension space to actually find providers willing to accept individuals with a US residency. The next question is to do with the size of his pension pot. If it is a small pension pot, potentially the route of having a SIP doesn't work for him moving forwards. The reason for this is that when he moves to the States, he's going to have to report the income and gains on this pension. And if you're going to do that, you need to have a certain type of portfolio which allows you to see through the entire portfolio, each individual line of stock, each individual line of bond. It's very likely that David has a series of unit trusts in his pension, and therefore he could fall foul of PFIC rules once he is in the States. When he's here, he's absolutely fine. PFIC is a passive foreign investment company scheme. Essentially, in the US, it is a mutual fund. In the UK, it is a unit trust or an OIC. But the US tax authorities do not like US individuals holding these assets, as they believe they're avoiding taxation. Therefore, when he goes to the States, he may well be better off realigning his pension accordingly, so he's got a clear, transparent portfolio. Now, the problem with that is if the pension pot is too small, the cost of doing that is onerous on David. So he might actually be better off having or moving that money from a SIP into a personal pension, providing he can find a provider who will allow him to have a US address. That way, he could then just report the income and gate, or the value at the start of January, the value of the 31st of January, and the highest value in the calendar year. And that way he can then report it as a foreign pension. So the issues of whether or not the SIP provider can actually report properly will come into whether or not he should have that SIP. Obviously, we would be looking to review his attitude to risk, his capacity for loss, to understand whether or not what investment he actually has is suitable for him. We'd probably also then look at the time frame. So David is planning initially to go for a few years, but the question will be, is he thinking longer term? You know, if this works out, will they stay? If he stays, he's then got some foreign exchange considerations to bring into play, all of which needs to be discussed.
And Matt, that's the SIP. What about the ISA?
Well, Scott, there's a strong possibility that David is holding unit trusts, OICs, or EU-registered trackers, rather than direct equities or bonds. The issue when he goes to the States is the same as with the pension, in that if he has these holdings, they will be deemed PFIC and they'll be then chargeable to a penal taxation. It would be much better pre-leaving that he sells out of these holdings and then buys into solutions that are available for US connected individuals. That's useful within the ISA because there's no capital gains tax, there's no income tax in that switch.
And I believe it's the case that once he's no longer resident in the UK, he cannot make subsequent contributions to the ISA while he's not resident.
Correct.
In step 2, we'll talk about planning while in the US. So Gurpreet, tell us about what happens with the family home being rented out versus being sold.
Sure. So firstly, I would cover the UK side. So because the property is rented and it's owned jointly, David and his wife would need to file the UK tax returns to declare rental income and expenses in UK, and UK taxes would need to be paid every year. So that would be the first step that would need to be done. David and his wife needs to declare this on the US side. So they would need to pay US taxes as well as UK taxes. Make sure UK taxes are prepaid every year in December or earlier, so he could take foreign tax credit on his federal tax return.
And Christy, when he's in the US, how long will he have before visas need to be updated or renewed?
So that does depend on the visa, and they all have slightly. It doesn't make it very easy, does it? But it does. They all have slightly different lengths and durations and renewal abilities. So generally speaking, if we go with the E2, which is my preferred route, and they do get the 5-year visa, the visa would only need to be renewed every 5 years. There are some tricky things because once they enter the US, on an E2, they're only admitted for 2 years. And so I don't have a problem with Brits because they travel enough, and so it's not an issue. But when it is COVID, for instance, you suddenly find yourself not leaving the US for 2 years, and we can run into problems because they're not been admitted. But generally speaking, an E2, we would have to send them back to the embassy, they would have another appointment, get their visas and go back. If, on the other hand, we had done this L1 that we talked about, the L1 is done first in 3 years, then 2-year extension, and for managers, another 2-year extension. That's first done in the US. So it wouldn't necessarily affect David and his family because it would be being done by the employer behind the scenes up until the 5th year, and then David would need another visa. So I think really the key is that they'll need to be aware that what their visa category is will determine how long they can stay. The E2 has no limit. Every 5 years, you can just keep renewing, which is fantastic, as long as, of course, the company continues to maintain their E2 registration. So that does work really well. But I think the main thing is just make sure that they're planning in advance, because sometimes they could travel abroad and not realize that now they can't get back to the US because they've not gotten new visas.
Right. And in terms of the children, as time goes on, you mentioned that it's fairly straightforward. Perhaps to get visas for minor children, but what happens as the children are approaching their 21st birthday? Perhaps they're in university in the US and they're not quite ready to no longer be dependent? What does that look like?
So at 21, a child is no longer considered a dependent, which means they do at that point have to find their own way. And so if I was counseling David and I said to David, what's the long-term goal for your family, for your eldest child, the 21-year-old child? Because ultimately, if they're going to come back to the UK, probably don't need to start exploring long-term options, which we can discuss in a minute. So we would be looking at short-term options, like maybe getting a student visa for the 21-year-old, an F1 student visa, which actually would then give them the ability to work. And in some cases, I do get student visas for students for that reason. They work towards the point of once they've graduated, they can get special authorization to work, which is great because they wouldn't have otherwise been able to do that as a dependent.
And Matt, while they're in the US, they're earning money, dollar-based, certainly they will want to think about investing their spare money. And to the extent they want to keep some money in the US, what do they need to think about in terms of keeping one eye on moving back to the UK at some point?
Yeah, they find themselves in a tricky position with their longer-term planning. So typically in the States, people would pay into 401ks, equivalent of a group personal pension here, or IRAs, which are equivalent of SIPs. Their issue is if they move back, they haven't built up a lot of money in these pots, and they have to be custodied and kept in the States. And therefore that becomes an administrative hassle for them further down the line. Their issue, if they move back, is that the provider in the States won't allow them to change their fund selections if they've got a UK address. So again, the same problem but in reverse.
Right. And again, they'll also want to bear in mind exchange rate exposure, because if they're thinking of the future in sterling,
yes,
that's one set of thought processes.
Yes.
If you're thinking dollars, it's another.
Yes, absolutely. The FX is critical in that consideration, and making sure that you base your portfolio's currency in the currency in which you intend to spend the money is a smart move. The one tax issue that they need to be aware of is investing in mutual funds in the States in a brokerage account. Because if they come back to the UK and they're selling those investments, they could then find themselves liable to offshore income gains from HMRC.
So that is sort of the mirror image of the problem they've got before they go to the US.
Absolutely.
The US doesn't like anyone else's mutual funds and unit trusts, and the UK doesn't either.
Yes, and we've done a bit of a tit for tat.
Yeah,
yeah, absolutely.
Okay.
So in step 3, we'll discuss what happens if David and the family decide to stay in the US long term. And I think in practice, we've all seen individuals who went on international assignments completely expecting to be in the other location for 2 or 3 years. Yeah. I came to London 25 years ago expecting to be here 2 or 3 years, and I'm still here. It's the same with my Brits in the States. Many went, California, New York, and think they'd be there for a couple of years for a project, for a specific task. And then 20 years later, they're still there. So what happens from an immigration standpoint if David decides he wants to stay in the US? What are his options, and what does he need to think about in terms of timings?
Yeah, so it's you're absolutely right. It happens all the time. And the one thing I'll say is everything that I'm going to say is going to completely be against the tax advice, because that is always what it is. There's always an opposition. They say, my tax advisor says, don't get a green card. And I say, but you want to stay. You have to get a green card in most cases. So the E2 visa, as I said, if that's the visa they go on, I mean, David will be tied to his employer, but could, in theory, continue to stay long term. But realistically, what we're talking about is how do we get David a green card, and how does he get to stay permanently? So a green card is the colloquial term for permanent residence or a legal permanent resident. Unlike the E2 visa, which is an indefinite, as long as they do continue to work for their employer, and renewing it every 5 years, the L1 does have limits. So the L1 will max out at 5 years for specialized knowledge employees, or 7 years for managers. So if David maxes out at 7 years, he has to come back to the UK unless he's thought ahead. And so when we talk about thinking ahead, we're talking about becoming a legal permanent resident, getting a green card. The process is long, as with all things in U.S. immigration. It takes a very long time to prepare, to get it filed, and the processing times are long. So we need to assess. We only have a handful of categories in the green card space, which is good. And so the EB1 is a multinational manager green card. It lines up almost identical to an L1A, which is the managers, and in a lot of cases could also work for the E2. So that would be if he worked as a manager abroad for the company for at least a year. If he did work abroad as a manager and now is in the US as a manager, that's going to be our best option because it doesn't require a test of the labor market. So no advertising to find out that there's no qualified workers to take the role. And so my recommendation will always be let's check for an EB1, which is the multinational manager, an executive green card. If maybe David didn't work for full 12 months, or maybe he didn't have a full 12 months of being a manager in the UK before he went to the US. If that's the case, we're going to, I'm afraid, have to look at what's called the EB2 or EB3 categories, which does require a test of the labor market. And we have to determine that there's no qualified, willing, and available US workers. It means they have to advertise for David's role, saying this is what the minimum requirements are for this job, and hope that nobody applies. So that process, the EB2, EB3 process, could take 3 years or more for a Brit. For some nationalities, Indian nationals, Chinese nationals, could take 15 years because of backlogs in visa availability. So in this case, David's British. As long as he was born in the UK, we wouldn't be worried so much about that. So EB1 would be my recommendation, but you're going to want to allow at least 2 or 3 years, so you don't want to push it all the way up to, if he's on an L1, my L1's about to expire, what do we do? Yes. You pack and hope that you can get it done quickly. The good news is, with the EB1 or the EB2 or 3, the family all comes under as dependents. And so there is going to be some strategy planning here for those kids, because you need to make sure that you get to a certain stage in the process to capture the 21 before they turn 21, the oldest children. So you want to get in there quickly. I typically would recommend, especially on an L, that you start talking about doing an extension and also talking about doing a green card. So at the same time, sort of 3 years into the assignment. They know by then if they're committed to America or if they've had enough. So by that point, that would be good. And then I think long term, we would start thinking about things like naturalization. So provided David is not married to an American, which at the time he left the UK, he wasn't. I hope it remains this way. He would then be eligible to naturalize 5 years after he became a US permanent resident, provided he meets certain requirements, like he's physically in the US for at least half the time. Because you could lose your green card if you leave for too long and they think you've abandoned it. So it's important that if you're going to get the green card, you need to be staying. I get a lot of calls from people who say, we're moving back to the UK, but we want to get our green card. And I think, well, why? So that's something you definitely want to really find out. What is their plan and strategy, and think about it long term.
The same time they start worrying about which sort of green card or visa they need, they also realize that having a rental property in the UK isn't as fun as it used to be, and are looking at perhaps selling that property. What do they need to think about at that stage in terms of the tax position?
Sure. So first of all, they will need to look at the UK side, because a non-resident in the UK, if they sell the property, they need to file a non-resident tax return, capital gains tax within 60 days. And pay any UK tax within 60 days. So that gets missed quite a lot, so that was something they should consider. And then on the US side, again, when they sell the property, which I discussed earlier, they would need to pay US and New York tax as well. And then another thing they need to be careful of is mortgages, foreign mortgages. So from a US tax point of view, foreign mortgages are considered as a separate asset. What would happen is if they took out a £100,000 mortgage a couple of years ago when the exchange was 1.35, and they're paying it now when the exchange rate is 1.2, from a US point of view, they will say that you have made a gain, foreign exchange rate gain. In paper term, there is no gain, but from the US, this will be considered a gain, so they would need to pay US tax on this side.
Yes, and that's very tricky, and it also, given how much exchange rates have moved around in the last 10 years, it's something, it's not intuitive. You've really got to know that particular trap is there. In terms of remaining non-resident in the UK, because that will be important to them from a tax standpoint, how much time could they spend back in the UK and not be considered resident?
Generally, we would say spend less than 90 days in UK because you're looking at a number of years going forward as well. Because one of the ties in the UK is 90-day ties. A number of ties in the UK, and one of them is 90-day ties. So the more ties you have in UK, the less amount of time you can spend in UK before becoming a resident. So we normally recommend spend less than 90 days in the UK.
I would recommend that as well, because that way they're not jeopardizing their abandonment of their green card, assuming they've gotten green cards, because an officer at the border will say, why are you gone so much?
Yes.
Why have you been gone so long? And so obviously minimizing trips out. Yeah. That's the only time we're going to agree on tax.
Yes, and it is really important because, again, it just shows that there really are two fairly complicated sides to each question.
Indeed.
Yeah.
And Matt, at this point, David's further along in his career. Perhaps he's planning to stay to retire rather than stay to continue to work. But he has UK pension funds. He's now resident in the US. And perhaps either he wants to draw on those funds or he wants to know what the process is when he reaches the stage where he wants that money. So what are the challenges that a Brit resident in the States will find, or an American who's returned to the US will find with moving pension funds from the UK to the US?
Well, the issue will come back down to some of the practicalities of managing a pot in the UK versus drawing down a pot in the States. So you've got a currency issue. So does the SIP provider pay out in dollars? David could well have managed his money very well over the preceding number of years, but with a base currency of sterling, and he now wants to draw it out in dollars. There's a mismatch there, and that's going to hurt him financially. So he needs to make sure that his SIP provider can pay out in dollars. Not all of them do, and therefore it's a bit of an exercise making sure that is dealt with beforehand. In terms of drawing the money out, if he's got no other income in the UK, he could potentially change to an NT tax code, a not tax code. That is an arrangement between the IRS and HMRC. Lasts for months in terms of the setup, but once it is set up, the SIP provider in the UK will pay David that money free from UK tax.
And I think, again, it's a really multidisciplinary problem in that there's the financial side of it, there's also the tax side. You mentioned about the NT code. Of course, from a tax standpoint, we're looking for that because there is an agreement between the US and the UK that basically says, regular pension payments are only taxed in the jurisdiction you're resident in at the time of receipt. So you don't want the UK pension provider withholding tax when tax is also due in the US. As you say, that can take quite a long time to process that arrangement. And then the taxation of lump sums is a completely different treatment between the two systems. There is an agreement that provides some potential benefits, but again, it's not the sort of thing, if you want the money next week, that you make the application. There are things to put in place ahead of time. So finally, we'll just conclude with a summation of the benefits of seeking advice before, during, and possibly after the assignment to the US. So Christy, what can your firm do to help someone in David's situation?
So I think that one of the key things is that by contacting us early, we can help them to plan ahead and ensure that they're avoiding any kind of pitfalls or concerns, and that we can really develop a strategy with them. Often, especially with company transfers, when a company is maybe setting up their business in the US for the very first time, they think about, we need to send people to the US, but they've not actually thought through how should they structure the business. But how they structure the ownership of the company makes a huge difference. So if I get in very early and start advising them early, it helps them, and they can kind of have a roadmap of what does it need to look like. I think in my experience, when it has happened where companies will come to me and they say, well, we've set up our business and this is how we've done it. And to make things easier, we've got an American who owns all the shares. And I think, well, that's not going to help me at all. Why have you done that? And they, well, we thought it was the best idea. So I just think by having that chat, and I always send them to tax advisors as well. So as soon as they've come to me, I say, you need to seek tax advice because we're not going to agree. I'm sure of that. Every time, as if you're setting up a business in the US, we're not going to necessarily agree, but at least then you get to make decisions. So I would definitely say, and I think also it's a long process. So don't come to me 5 minutes and say we need to be there, because often I get, well, can't we send them on ESTA? Well, no, because that's for visitors. And so, I think, and there's any number of things that could even delay the process. If the person has ever been arrested, that's a big one. And so, I think we really need to evaluate really early on and help them. And so that's what we do. And we talked about L's and E's today, but we do visas in our office for all categories, and every category is different. It's very factual, very specific, and I don't expect anyone to know all of the numbers and letters that go along with all the visa types, but it's definitely something to seek advice on. So
absolutely.
Yeah.
And Matt, what can your firm do to help people in David's situation?
I think the overarching benefit of seeking out independent financial advice is that if we do our jobs well, David or a client would leave understanding their situation so much better, helping them make informed decisions. So for some, it could just be peace of mind, knowing that someone who is regulated, authorised and qualified can help them. For some, it's the objectivity, not being tied to a particular fund manager, looking to steer investments in a certain fashion. Essentially, the knowledge and expertise that we can bring helps these clients avoid the pitfalls.
Gavit, on the tax side, how can we help?
As you know, majority of us are dual tax handlers. We specialise in US and UK taxes. So what we can do is we normally look after Americans in the UK. We also look after Americans going to US in terms of tax compliance, and we can provide tax advisory. As Christy said, that pre-planning is very important. So we can look at and review investments with Matt and go through a structured plan in terms of what should be done before they go into US. Once they're in the US, then it's obviously the tax compliance they need to take care of. There is a US-UK income tax treaty between both countries, but there are some differences, and you need to be careful of these differences. So this is where we will come in and look at someone's tax structure and decide whether something is working in both countries, a dual compliant or not. At the same time, I think pre-departure meeting is very important. We should look at that. What we can do, we can help you understand what your requirements are, what needs to be done, and how we can help you together and then get you through.
And I think the thing, perhaps a key takeaway, is that these areas are all very complex. There are quite rigid rules. And as between the US and UK, whether it's immigration or financial planning or tax, there really is no scope to just hope that, if something goes wrong, you can seek forgiveness rather than ask permission. All of these arrangements are very much about you play by their rules, and it's very important to understand that from early days, I think. Thanks to our speakers for joining us today, and thank you to our listeners for tuning in. Plan your next step by looking at the other episodes in this series, covering the topics of business, property, investments, and more. Thank you.
Thank you.
Thanks.
Thank you.